Okay, folks, this is our last module on contracts. And we've already learned about what a contract is, the essential elements, and things like assent. Now we're looking at the concept that there could be third parties that are affected by a contract. And we're also going to look to see what rights they might have and just basically how that relates to the contract. Remember, the contract was between two, for simplicity, we'll say two people or companies, right? And so now we're looking to see, well, if there's two that are the parties to the contract, what happens if a third party comes into the contract, or how does that third party have any rights to the contract if that person or company is affected by it? So we're going to look at that. And then we're also going to look at ways that you could modify, and I don't mean modify a contract in terms of the terms really, because we've talked about that, but we call this discharge and remedies. So that would be things that would be at the end of a contract that could maybe be an agreement to change it or to excuse non-performance. And what happens if it doesn't work out? How do you get your I say your remedy, meaning to be made whole. So we're going to look at those kinds of things in this module. And firstly, let's see third parties, just a couple words on it. And I want you to actually read it in the book and see what it is that, the hypotheticals there, how it's set up. And I say the book, but the ebook and your exercises and self-learning is really a good way to kind of work through these different scenarios. I'm just setting up your context for you as a supplement. And so what I'm looking at here, when I think of third parties, I think, well, there's a couple of ways that could affect. You might come to mind right away with, oh, what about can I sublet my apartment? And in that situation, we're talking about third parties stepping into the shoes of one of the other two parties. And so we call that assignment of a contract. ASSIGM, well, NMENT. I'm used to my board to write these words, but assignment of a contract. And the idea is you want to give somebody else the rights that you had under the contract. There's a couple key things there. One is that you must have the third party not disadvantage your other one. So you have an agreement with someone, third party steps into your shoes, and the person who you had the original agreement with does not have any disadvantage from that. So that means, let's say if it's a rent situation, a subletting situation, then you'd have the person coming in and the landlord still receives the same amount of rent. And so the person stepping into your shoes has the same rights and responsibilities that you had. And you have to give notice. That's the other key factor. And first and foremost, it has to be an assignable contract. So some contracts, you couldn't do that assignment at all. And it would say it in the terms. And I'm sure you've seen this where the lease says that you can't have a sublet. You can't assign your contract to someone else. It's very understandable that a landlord might do that because they've vetted you very carefully. They don't know who you might sublet it to, and they don't want the property damaged, that kind of thing. And so the first thing to do always with a contract, now that we've really gotten to the end almost of contracts, I want to give you some of that general advice. The first thing to do is read your contract because, as I said before, you can't say I didn't read it ever. And you are going to be bound by the terms unless there's something that is really against public policy or illegal term in that contract. So you look and you see, is there a clause in the contract that says that you can sublet it? If there's nothing that says you can't, the general rule is that contracts are assignable. So the landlord would have had to put something in there saying that you cannot sublet it or cannot assign this contract. And if there's no such clause in there, you're good to go. And that means that you still have to do it properly and give proper notice so that there's an awareness that there'll be somebody else stepping into your shoes, right? So the landlord knows that. And this is true with most contracts that are assignable. Most of them are, that's the general rule, with the exception being if there's special services or special nature that then really can't duplicate. So you get some great artiste to write you or to draw you a beautiful mural on your wall. Well, then you can't have just any old artist step in and take on the job. It's not the same as, rolling down the roller down the wall. And so if somebody shows up at your door and here you had an agreement with that artiste to do a beautiful mural on your wall, then you can deny that person and say, you do not have the right to step into that contract because it was a special nature of skills and services that I was contracted into. So there are those exceptions you're going to see. The other last thing about third parties that I wanted to tell you is that sometimes if there's a contract between two people, let's say, and third party benefits from that contract, they might want to sue one of the other two to make sure they perform the contract because it's in their best interest. And can they do it? The answer is it depends. It depends on the relationship between the third party and the other two, in that if you were the next door neighbor and this guy was next door with a great landscaping business contract and everything looked great, you are the third party beneficiary. You happen to live next door and benefit from the contract between the other two, the neighbor and the landscaper. But if things go south in their relationship, you can't sue and say, go and get your lawn done nicer because you had no right to that originally. You just happened to benefit from it. But if you were owed a debt, let's say the creditor of one of the other two, and let's say somebody owes you $25 and he says, well, I don't have the money, but I'm going to let Joe pay you because he owes me $25. Well, in that case, you do have the right to sue from either to either have Joe or the other person, your friend, reimburse you for that $25 because you are a creditor beneficiary. You have some connection there with that debt. And then the last kind of beneficiary is a donee beneficiary. You go from this class and you say, I have learned so much contracts from Professor Strauss, and you go and you have a very successful career, and you say, it's all because of that, and I'm going to put Professor Strauss in my will or in my, how about life insurance policy, even better, because there's a third party, that would be me, and there's you and the life insurance company are the two parties to the contract. And now, I'm not asking anyone to do that, by the way, it's just a great hypothetical. Now, the insurance company, which is the second party, says, no, no, we are not paying out to her. There's no relationship there. I would have the right to sue the insurance company because I am a donee beneficiary. I was the donee, EE at the end, to your donation to me. But I wouldn't sue you, and I couldn't anyway, because that was a gift to me. So you see, there's little nuances depending on the relationship between the third party and the other two in the contract, that relationship. And you'll see as you go through the scenarios, you'll get to learn more about that. And a couple last words, whether they're in the chapter or not, I always like to add a couple things about what you do if you are after the fact wanting to accept partial payment, let's say. That's called accord and satisfaction, ACCORD. So if somebody gives you a check and they're paying off the balance of something, let's say, and you say, well, this isn't enough, and you don't want to accept that as full payment, be careful, because if you deposit it in the bank, that looks like it's your acceptance that that is an accord and satisfaction, that you're taking partial payment to satisfy the entire debt. This is good, like this is good advice for people going out into the world to live your life, and it is contract, so I like to throw this in. And so what I would say to you is, doesn't mean you can't deposit the check, but there's that little memo part of the check. There's the part in the back of the check. You can say partial payment only and then deposit it because you're only accepting it as partial payment. Conversely, you're handing somebody a check and you want it to be the full payment. And so you could write on that memo section, balance payment in full. And then when they deposit the check, they're really accepting that that little mini contract on your check is the accord and satisfaction, the new arrangement that you have reached with the other side. So these are all little tips to be aware of because you are entering into contracts every day, whether you realize it or not. And the last big kind of concept I want to give you before exiting contracts in this video is the idea that beware, because the terms of your contract are really the entire entity of your agreement. And what I mean by that is if you do have a contract in writing and you sign it, well, if you then say, well, wait, he told me this or she told me that, and it's not in my contract, and you try to introduce that evidence, even if it's in fact true, you won't be able to do that because we, the judicial system and the judges, will look at that and say, well, we want there to be what we call sanctity of contracts. We want the contract to be of value. We can't go around undoing people's contracts just because somebody says something else was said. Because what would happen to the stability of the world then in that situation, our world of contracts and the economy and all the rest? Okay, and it's called, so I'll give you the explanation first so you understand the concept, and it's called the parole evidence rule. PAROL, no E at the end. This has nothing to do with getting out of jail, free or otherwise. It's called the parole evidence rule. And what we do is we say that evidence is not allowed to be introduced that would contradict the contract. So whether it's an email, something in writing, even if you have a tape recording of the person telling you, let's say that you have a lifetime guarantee, you get the actual contract and this is a 1-year limited warranty and you've signed it, that is what, in fact, you've just agreed to. So read the terms of your contract. The only time you're allowed to bring in that extraneous evidence is if there's an ambiguous term and you want to introduce that as evidence to explain a term, like it says industrial grade carpeting. You're allowed to introduce evidence to show what is industrial grade carpeting, but not evidence that would contradict the terms of the contract. So read your contract well. That's my last words of advice on contracts to you, and enjoy the module and learning the finer points that will give you good skills in this area that you'll use in the future.